Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
This morning, I was upstairs. I was doing Gary.
They're not muted. All right. What's your name, sir?
Damon, Washington.
All right. Mr. Washington has 3 cases before me. Any objection to my calling them all at the same time?
That would be great. Thank you.
No objection, Your Honor.
All right. Thank you. All right. We have case number 210-456-6801. People versus Damon, Washington. This one with a bond at $1,000, 10% due to on capias for failure to appear at the pretrial in February. Then I have case number 230-455-1401. People versus Damon, Washington. This one, same capias, 1,000, 10%. Failure to appear at the pretrial in February. Then I have 230-448-1701. This one, $100, 10% capias for failure to appear at the pretrial in February. All of them resulting from, this last one, retail fraud in the 3rd degree. The one before that, illegal entry, breaking and entering without owner's permission. And then that first one from 2021, we have a misdemeanor A and B. All right, positions as to bond.
Lisa Coyle appearing on behalf of the people, Your Honor. Your Honor, because
appearances first. Thank you, Ms. Coyle. Appearances first from the people and from the defense.
Lisa Coyle appearing on behalf of the people.
And yes, Your Honor, Brandon Bird on behalf of Damon, Washington. My client waived his right to the formal reading and will stand mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on Mr. Washington's behalf. Positions as to bond.
Your Honor, as you can see, there's been a long history on the retail fraud case ending in 17. He has 3 cases just on that matter. On the assault and battery back in 2021, he has 6 cases on that matter and only 1 on the 2023 case, Your Honor. I'm recommending that bond be left as they are, Your Honor. And also, if you're going to give a personal bond, a tether, because there's got to be something to get these cases forward. That at least a tether.
Thank you.
26-year-old lifelong resident, Your Honor. We do have three different cases in front of. I understand it's multiple capias. My client is on Social Security disability. Any amount of bonds is going to be like a remand to my client. We don't have any excuses, Your Honor, and we're not about to design one for the court. We did have a thorough discussion with my client about showing up to court, and hopefully we got through to him by that discussion. Respectfully, I do understand these are Judge Bryant's case, and that docket's pretty filled up into July. Unfortunately, my client most likely will be in jail roughly until July if he doesn't get a personal bond in this matter. I do see he provided us with an address, so he's not homeless. I usually would ask for not a tether in these matters, but I do understand these cases got to go forward, Your Honor. The only thing I fear about putting a tether on him is he's not going to be able to afford it, and we're setting him up for failure. But respectfully, Your Honor, we're going to ask the court for a personal bond in this matter, in these matters.
Oh boy. Okay. Madam Clerk, is this the soonest we can get him in front of Judge Bryant in July? Yeah, let's see if we can get a hold of anybody. Yeah, my concern is that a tether is going to keep him in. I know you're saying he's got an address, but PDC is reporting that he's homeless. So I'm not sure which one is which. And if he gets a tether, he's got to be tethered somewhere. And you're saying he really can't even afford that. A cash bond in any amount sounds like that's going to keep him in. These are misdemeanors, but he's not showing up for court, and I've got to do something.
Right. I mean, we're at the point where we're spinning our wheels.
What I'm going to try to do
everyone's
is
given a lot of.
I'm going to get him an earlier court date. Let's hold on. If I get him an earlier court date, then I'm going to be more comfortable just imposing the capias that's been placed.
June 7th is the earliest. You can't schedule anything last week in May.
All right. Okay, so we'll do that. But then he'll also get a bond review. And so maybe they can work with it next week as well at the review hearing. Okay, here's what we're gonna do. The capias are going to stay in place given the number of times court has been missed. I do find there to be a flight risk that can't be managed outside of some amount of cash bonds. Respectively, the case ending in 701, the capias will remain at $100, 10%. In the case ending in 401, the bond will remain at $1,000, 10%. And the case ending in 801, the bond will remain at $1,000, 10%. What that will trigger, though, is that he will get a bond review hearing Monday, and then hopefully we can get the dates moved up so that he's not stuck in there. We were able to get it moved up by a month or more to June 7th. So the bond review will be Monday, May the 20th. Okay, that's going to be in McConico's courtroom for review. And then his pretrial date is going to be June 7th in front of Judge Bryant. On all of the cases right now. Hopefully when they address it at bond review, they'll be able to get it, moved up even more, get it handled in some other way so he's not stuck in there on these misdemeanors. All right.
Very fair. Very fair. Thank you.
Okay. All right. All in front of Judge Bryant, June 7th, and then all in front of McConico or in his courtroom, May 20th. All right, Mr. Washington, take care. You ready for Mr. Burg? Give me just 1 second to finish up this paperwork, and then I'm ready. All right, you can go ahead.
My name is Desmond Burg.
All right, Mr. Burks, good afternoon. Oh, there we go. All right, calling case number 240-572-4801, People of the State of Michigan versus Desmond Burks, counsel.
Thank you, Magistrate Stevenson, for the people, P71917.
Yes, Your Honor. Brendan Bird on behalf of Desmond Burks. My client waives his right to the formal reading, was advised his constitutional rights, so will stand mute.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on Mr. Burks' behalf. I will hear arguments as to bond.
Respectfully, Magistrate, we're asking for remand. Allegedly, a minor rear-end accident has led to an individual who passed. We have a defendant actually who admitted to the fact after substantial investigation that he ended up striking the individual that subsequently died from blunt force trauma to his head. The complaining, well, not even the complaining witness, the deceased victim was 67 years old. Defendant is 33 years old. Apparently both individuals get out of their vehicles following the minor collision. The defendant strikes the 67-year-old, and then based on the injury that the 67-year-old sustained, he ended up succumbing to that injury and lost his life. The defendant does have priors, Judge. The way that I read it off of Otis, he was just released from prison on that arson conviction from 11. He was released in 22, in July of 22. And Judge, there's just substantial, at least the way I read it, and this was pretty comprehensive, a lot of investigation, but there was just substantial alleged evidence supporting the charged offense, with the green light, with the flock, with somebody actually allegedly seeing this incident take place, with the prior and post regarding the defendant in this vehicle, the post following the accident, seeing this vehicle with the damage that it had sustained from the accident, and then ultimately that admission from the defendant, Judge. So respectfully, we're just asking for remand.
Thank you.
Yes, Your Honor. 33-year-old lifelong resident indicates to us that he's homeless at the moment, Your Honor. Indicates that he's not on probation or parole and doesn't have any pending cases. According to the complaint, his last conviction was in 2011. States that he's in school right now for nursing assistant on a lot of medication, Your Honor, but well below the 200% poverty guidelines. We could Marcus file medical, it'd be greatly appreciated. Now, I did get a chance to read this report, Your Honor, and right now we're not accepting the facts to be true at this juncture, but for argument purposes, if they were true, if the facts were true in this matter, this would seem more like what would have been an assault and battery, but we have an eggshell rule under that. We have an eggshell rule in which, unfortunately, we have a dead person at the end of this, which is never good. So what I'm getting to with the remand status, I don't believe that if the facts are true in here, it was an intent to kill, even an intent to do great bodily harm. I never heard that it was a weapon that the person was struck with, that the person was struck multiple times in this matter. When I did read the report, it indicates that it's alleged that a collision happened. Two people got out arguing with each other, and my client allegedly strikes the victim. And as I said, I at least I don't see it in the report. And please clarify if you can. But when it says strike the victim, I didn't see any. I didn't read any evidence of a weapon, Your Honor. So, but hopefully I didn't read over something. But that's why I'm saying I don't believe this was actually an intent to kill. I don't believe it was an intent to do great bodily harm. We are walking along the lines of willful disregard, but with the likely natural tendency to say that death would occur or do great bodily harm. I don't really even think that was the intent or belief at that time. I believe it was I believe if the allegations are to be true, it was an argument that happened. Somebody got hit, and we're working with an eggshell rule where unfortunately we have a victim that's dead at this moment, as I said, which is never good. But that's why we're not that's why we're asking for not a remand, Your Honor. We're asking for. I understand the court probably in the position maybe where we can't give a personal bond. I would ask for a personal bond in this matter, but if the court's not inclined to that, we're asking at least for a reasonable bond set by the court, Your Honor.
Thank you. Even if we were not dealing with a decedent in this case, I would find there to be a high degree of risk to the community. These are some of the most scary cases that we deal with, where we have a random, and I feel like we're starting to see more of them, where we have these kind of random car accidents, people that have no prior history with each other, no beef with each other, and now people are attacking each other over a car accident. Instead of calling police, instead of waiting for police. I have allegations that a person who is 6'4" and in his 30s hit an individual who's 67 and much smaller so hard that with a single blow, he is unconscious in the middle of the street. That is concerning. The parties were unknown to each other. It could have been any member of the community. So outside of eggshell, outside of a person even being deceased, which, I mean, it's important, but outside of that, even without that, I would be finding there to be a very, very high risk of danger to the community here, given the allegations and given the admission by the defendant that he did in fact hit the complaint, the decedent. It's not charged as first degree. You know, so there's no one arguing that it was premeditated. It's real horrible, bad decision-making in the moment that placed the community at risk and ended up with a person dead. Because it's not charged as first degree, because there was not premeditation, I will set a cash bond. However, the cash bond is set at $1 million, no surety. Bond review hearing will be May the 20th in McConaughey's courtroom. Probable cause conference, May 24th. Preliminary examination, May 30th. Both of those latter two dates in front of Judge King. If he is able to make the bond, GPS tether with full home confinement. Right. Thank you.
$1 million. Come on, Burg. How am I get $1 million? Where am I get $1 million from? Stay in Detroit.
You're not supposed to, sir. If I wanted you out, I'd give you a $1 bond. I think you need to be in. It's intended to keep you in, but I am giving you the benefit instead of remanding you. I am giving you the benefit of seeing a judge again Monday, May 20th, so that they can take a closer look at the conditions of your case and decide whether or not they believe that is appropriate. All right. Thank you.
This don't make no sense. Just don't.
Please,
I bet the proceeding family would agree. Have a good day, sir. Good night, DDC.
please exercise. Thank you, Your Honor.
We're done.